very flat house. It's nothing at all. If you take one of these definitions away from the proceeding here today, then we have nothing at all. Judgment is the ascertainment of truth. It is the process of examining facts and arguments to ascertain propriety and justice. These are definitions in almost every dictionary you can find. Justice, then, is the administration of what is just. That is, being in conformity to what is morally upright and to what is true. Truth, that's something that many have asked for thousands of years. A very simple definition is its exacting accordance with that which is, has been, or will be. That is present, past, or future. It is what we say is reality. Truth is a purity from falsehoods and lies, and by its very nature is trustworthy. That is why every witness swears to tell the truth, the whole truth, and nothing but the truth, so help them God. Righteousness is that which arises from and includes all we call justice, honesty, truth, and virtue. I'm going to get talking in the facts here in a moment, and I'm going to be petitioning the court for a particular sentence. And so I want everyone to understand two more definitions, mercy and vengeance, because what I'm asking for has to be done from the right place. And if we don't understand these two words, it could appear one and not the other, or it could be an unjust request from the people to the court. Mercy. The benevolence, mildness, or tenderness of heart which disposes a person to overlook injuries or to treat an offender better than he deserves. It is the disposition that tempers justice and induces an injured person to forgive trespasses and injuries and to forbear punishment or inflict less than the law or justice warrant. Now, true mercy is impartial, meaning it is not based on personal preferences. It is not something that can be won over. It flows solely from the impartiality of love, joy, peace, long-suffering, kindness, goodness, faithfulness, gentleness, and self-control. Mercy that is partial is favoritism. And this system here today can't show favoritism. As the representative of the people of the state of New York here today, I can't show favoritism. My ask here today has to be impartial. True mercy is free from fear, favor, bias, prejudice, or sympathy. When you really consider mercy, there is no real word in the English language that is its synonym. Every word you can think of falls so short to that definition. The best you get is leniency, but that's just a softening. It's not even close to what true mercy is. However, in the English language, there is an antonym, there is an opposite to mercy, and that's the word vengeance. Vengeance is the infliction of pain on another in return for an injury or offense. When vengeance is sought with partiality, personal preference, it always proceeds from resentment, malice, or hate, and not from seeking justice or righteousness. In essence, it is the repayment of an evil for an evil and would be contrary to justice and to judgment. However, when vengeance is sought impartially, it is always in accordance with judgment and justice and is righteous. It is, like true mercy, also free from fear, favor, bias, prejudice, or sympathy. Our legal system recognizes this, by the way in which a case is brought against a defendant. It is brought by the people of the state of New York. It is not brought by an individual. And that is when the people bring a case and ask for a sentence, it is a type of avenging that we're asking for, but it's free from the partiality. Now, those are the definitions that help us understand what I'm going to ask for here today, and to put into context what we have. Because first, we have the judgment of conviction, what the jury found. They didn't just find guilt of murder in the second degree, of reckless endangerment in the first degree, of tampering with evidence. Their judgment found so much more. There's so much more meaning to that judgment. First and foremost, that the defendant is a liar. He lied to the police that night. By the case that was presented between the people and the defense, the jury had an option of choosing the people or the defense's version. By finding guilt, by the judgment of conviction, that which the defendant said on the stand was filled with lies. So the judgment of conviction establishes that the defendant is a liar. It also establishes that the defendant is a thief. And we just heard that from those victims on that stand. What is stolen from them in this case? There are certain innocences that are stolen from these kids, these teenagers, as young as 16 in a car. There are innocences now that are filled with cynicism, with skepticalness, with looking at people with a jaundiced eye, wondering what evil motive is there. That innocence is gone. The trust is gone. The joys of life are now filled with sorrow. They're clouded by grief. Their life itself is now going to always be measured against this event. That it would be difficult for them to escape these impacts. The peace that they're supposed to have in their life is now replaced with distrust and fear. And fear is a tormentor. It torments. Peace is what calms you, what brings all those other things into your life. And when that peace is robbed, you're tormented. And that's what he stole from them. They also, by the judgment of their conviction, and by the charge of tampering with evidence, found that he's a manipulator, a deceiver. I still wonder how the charade could go so far as to say to Jinx Monahan on the phone, he's on hold, I told you not to play the TV so loud. For whose benefit was that but to continue a deception? When the court considers the sentence, the judgment of sentence that needs to flow from the judgment of conviction, these are things it needs to consider. Finally, they judged him as a murderer. Murder in the second degree, which is the reckless, depraved murder in New York State, requires a wicked, wanton, evil mens rea. The jury instruction says that you are devoid of regard for the life or lives of others. And that charge goes on to say that the conduct is so blameworthy as to justify the same criminal liability that the law imposes on a person who intentionally kills. That is to say, as one whose conscious objective is to kill. Now, during the trial, it was important for the defense to make a distinction to the jury relative to their client didn't intend to kill. But to the judgment of sentence, that distinction is irrelevant. The law puts the two equal. And thou shalt not murder has been around for a very long time. It is codified in our law and is treated a particular way. So the judgment of conviction is a liar, a thief, a manipulator, a murderer. That's the judgment Now that judgment is the ascertainment of truth, which means that's the truth. And anything in this proceeding that would try to diminish the truth, pay lip service to the jury, should be ignored. I've often heard it said, well, while we respect the judgment of the jury, we disagree with it. That has no place here today. There is a judgment that this court must measure from. And that is the judgment to be measured from. That is the truth. A jury, by the way, who was selected because of their impartiality. We went through 3 days to find a jury, 12 people free from bias, fear, sympathy, favor, prejudice, that they would be impartial jurors to weigh the process of examining facts and arguments to ascertain propriety and justice, and they found it. They found justice, they found truth, and they convicted the defendant. And now this court, the impartial body that is to mete out the judgment of sentence, is to do the same. One of the things that I'm asked most by people who talk to me about this case is why? Why did he shoot? What was the reason for it? And that's a difficult thing to pin down, but the facts of the case, the facts that lead to the 90 seconds, and it's not just 90 seconds here, because the defendant made himself a judgment. The defendant attempted to make a judgment of a situation, he judged it, and he reacted. So it was less than 90 seconds before he made the judgment, because he had to execute his judgment. Fear and anger, hate and anger are the only things that I can possibly come to that would explain a mindset that's murderous in nature. The speed at which that judgment was made by Kevin Monahan on April 15th is the thing that speaks to it having been made prior to. Prior to that night, that decision's made. That's the gun by the bed. Now, I say all this because it has been said that judgment is without mercy to the one who has shown no mercy. That would be righteous. Meaning, to the person who is merciless, no mercy should be shown. Kevin Monahan was merciless in his judgment to act that night. And the question here then would be, should he be shown mercy? And based on that, the answer is no. How could there be mercy to someone so merciless? You know, and yet, our system provides an opportunity for Mr. Monahan to obtain mercy. He can either qualify himself to receive mercy, to be able to receive, or he can disqualify. The qualifications to be put in the place to receive mercy would be to submit to the judgment, to come under submission to that judgment and accept it as the truth, because that's what judgment is. Another qualification would be to accept responsibility for his actions, which is part and parcel with accepting the judgment. To be broken and contrite over the reality of the truth of the judgment in him, what it says of him, what I just went through, that he's a liar, he's a thief, he's a murderer, to come under that and be broken by that. Not pay it lip service, but to actually be broken. That's someone who's starting to qualify for mercy. See, on the stand, he said he had a hole in his soul. It fell so flat. Even with the tears, it fell so flat. Do you know who has a hole in her soul that was so prominent and so sorrowful? Was Catherine Rondon on that stand. When she came face to face on there with the thought that she's responsible for leading this group of people to this house, that made a hole in her soul. She was sorrowful. She's not responsible, but she could see it. She felt it. That's put into her. So these are the things that qualify someone for mercy for the court. So when the defense asks for mercy from the court, leniency from the court, give him less than the maximum, is there any acknowledgement of the actual judgment? That's the question for the court, if that gets asked of you. Will you accept the judgment? As is. Not with disagreements, qualifiers, asterisks. And I'm not talking about legal rights. There's a whole legal proceeding that happens after this, that always happens in cases. I'm talking about in this moment, for everyone in this room and everyone watching to understand, will the defendant accept the judgment of the jury and the judgment of this court? If so, then he's in the running for mercy. But I submit to you, he won't. And the thing is, he's already received the mercy. He's already received it. I cannot petition the court for the death penalty. It's gone. So as Alexandria Whiting just said up there, he gets to live his life every single day. What a mercy. What a mercy extended to him. Undeserving. It'll be lived differently, but he has it. What will he do with it? Will he spend his days seeking to come under the conviction of this judgment and to have it break him, contrite, sorrowful, that leads to, the English word for it is repentance, to lead him to repentance? Will he get there? That's the question. Because if he was there today, there'd be mercy for this guy. So relative to what I'm going to ask for sentence, there is an injustice. There needs to be justice. New York has the scales of justice, we could say. And people tend to think of it as scales, so I'm going to use that. We have an injustice on one side, so what balances the scale? What would make it just? What would everyone in here say, that's just? Well, we could put a weight on there of accepting responsibility. That would start to balance it. We could put a weight on there of brokenness. That would start to balance it. I mean, isn't that what every plea deal does? Doesn't the defendant offer up in a plea deal a weight to offset the injustice of his crime? But none of those weights are here. The only weight we have for a sentence here today to begin to offset the injustice is time. The defendant's time is the only thing that we can use to begin to set the scale of justice right. So the question is, how much of Kevin Monahan's time do we take? How much of Kevin Monahan's time is demanded to begin to set the injustice to just? All of it. All of his time. Every year, every month, every week, day, and hour. All of his time is what justice here today demands. And that's not from a vengeful place. That's not with partiality. It is with looking at all of this. It is a man who's shown no mercy, who's come under no conviction of judgment. Then the only thing left to begin to do it is to balance the time. Countless people's lives will be affected for generation, 2 generations. How much of his time should be punished to offset it, and for what purpose? Well, everyone out there needs to know that there is law enforcement and prosecutors and even defense attorneys and judges, that they know that there are people out there who are hired, who are appointed, who are elected that are seeking something to right what society we live in when we see so much wrong. In this case, for our local community in the capital region, this case.
That's not good.
This room has to walk away from here today going, you know, the criminal justice system, there is a way that it can operate that leads us in the right direction. That's what this sentence affects today. They'll either understand it and be led to hope, or they'll not understand it and reject it. And then the questions of why do evils happen in the world when nothing is ever corrected. That leads people to despair and worse. The other purpose of this sentence, and Andy Gillis talked about it, is that every other person out there needs to know that you can't murder someone because they accidentally pulled into your driveway. When I look at the comments on some of these articles that are written by the media and some of the videos that are played and people can comment, it is shocking to me how many people believe you can just shoot people in your driveway. So the sentence here today affects everybody. I'm asking that for murder in the second degree, that the defendant be sentenced to 25 years to life. I'm asking that reckless endangerment in the first degree, that the defendant be sentenced to 2 1/3 to 7. That is the maximum for that charge as well. By operation of law, and in the theory of the people's case, those two charges by law are to run concurrent with one another. Relative to the tampering with physical evidence, the defendant should be sentenced to 1 1/3 to 4, which is the maximum sentence. Now, in this case, the defendant tampered with the murder weapon. The question is, should that be consecutive or concurrent? It is the people's position that in the case of murder, it should not be a buy one, get one free. Because you've murdered and you're going to get a harsh sentence for the murder, therefore, the other conduct, which could run consecutive, should be concurrent. The people of the state of New York can't abide that. They have to ask, we have to ask, I have to ask, that it be run consecutive. You cannot tamper with a murder weapon to get away with murder and then not be punished for that. Justice demands consecutive. That means the people are asking for a maximum sentence of 26 1/3 to 29 to life. Thank you.
Thank you, Attorney Morris. Attorney Frost or Attorney Mauser?
Judge, when we get to this point in a trial or proceeding, it's difficult to know what to say. It's difficult to know what to ask of the court. There was never going to be a happy ending to this trial. No matter what the verdict is, there was never going to be a happy ending. I hope they take this in the way that I mean it. I genuinely mean it. My heart breaks for the Gillis family. Their pain is agonal, it's constant, it's exquisite. It will never go away. My heart breaks for the Monahans, for Jinx and Kevin. Both families are irretrievably shattered. That will never change. I've been doing criminal defense for 27 years. Very, very early in my career, I said to myself, if you can't find something to love in your client, you should not represent him. Kevin, I've looked at him hard, I've looked at the case, I've looked at the facts, I've looked at him hard. I have found something to love in him. And what I love in him is how he loves his wife. I disagree with many of the definitions Mr. Morris used, but I will credit him with this. Your sentence should be just. Of course, I never got to meet Ms. Gillis, but everything I have heard and read about her is that she was a vibrant member of the community, and the community is diminished by her loss. And when something that grotesque and tragic happens, there's a tendency to vengeance, not justice. It would be easy. It would be easy to put him in a cage, lock the door, throw away the key, melt the lock. The jury's verdict was what it was, so there must be a sentence. Mr. Monahan sits here guilty, according to the jury, and so you have to impose a sentence. He has no criminal record. I don't envy you your job. I've never had to sit in judgment of a man, and you do. I imagine it's a difficult one to do. I've had a chance to sit with Kevin Monahan. I think it's unfair the way Mr. Morris baits him into weeping and sobbing and throwing himself at your feet. I've seen his remorse. He lives with the fact, he lives with knowing that because of his actions, under any way you view them, because of his actions, this poor young woman is dead. So, I don't come here to ask you for mercy. I ask you to rebuff vengeance. I ask you to do what is just. Everyone has an opinion on what that is. I won't propose a number to you, Judge, because you have to sit in judgment. But I suggest to you it is not the maximum. Regarding the concurrent versus consecutive, I agree with Mr. Morris about the reckless endangerment first charge and the murder second charge. I disagree with him regarding the tampering charge because of the theory the prosecution laid out and because of their bill of particulars, which indicates an overlapping time frame. Based on that, I think from a legal point of view, you must impose concurrent sentences on all charges. Again, there's a tendency to look for vengeance instead of justice. I ask that you impose a fair and a sound and a just sentence, not a vengeful one. Thank you.
Right, and now, Mr. Monahan, at this point, you can say something if you want. You don't have to. It's your decision what you want to do.
No, thank you, Your Honor.
Okay. Well, first, I really want to thank those of you who came up here today and gave victim impact statements. It was very important for me to hear those, and they're taken into account in my sentencing decision, and I want you to know that. So when I'm sentencing a defendant as a judge, there's certain principles that I think about. Attorney Morris touched on one, general deterrence. And that is sending a message to society at large that there's certain behaviors that will not be tolerated. And Mr. Gillis spoke to this in his victim impact statement. He said such acts of violence will not be tolerated in our society. I think it's important that people know that it is not okay to shoot people and kill them who drive down your driveway. I know in the county where we live and probably other countless rural areas, it's a pretty common occurrence to drive down a wrong driveway. It's a common occurrence for somebody to come down your driveway. And there's definite choices that you get to make at this time, and the choice made in this case is absolutely not acceptable. Then I'm also guided by the principle of specific deterrence. Specific deterrence is directed directly at the defendant. It's saying, basically, you need to be prevented from doing things in the future. And Mr. Monahan, I think if you were released from prison, and people who commit murder generally don't recidivate a lot. They don't commit the same crime again. It's a low rate of recidivism. But with you, I think you really could possibly do the same thing again. It's obvious to me that you feel justified. You don't take any responsibility for the outcome of your actions. You just don't get it. The first thing you do on the witness stand when you come up here and testify is you made a joke to the jury about them finally being able to see your face. You senselessly took the life of Kalen Gillis, and you have the gall to sit here and talk about how you plan to finish up the work on your house and race motocross in the future. You don't deserve that. What would make you think that you deserve those things? Even when your attorney tried to get you to acknowledge that your home wasn't being invaded, you couldn't do it. You hesitated and said something to the effect of, "It sure felt like we were being invaded." He was trying to elicit out of you a response that somebody who took responsibility for their actions would have, and you couldn't even do that. Your first instinct was to lie about what happened, and you repeatedly lied in such a cold and calculating manner. And the jury saw right through your lies, and they rejected them. In killing Kalen Gillis, you took away a friend, you took away a girlfriend, you took away a daughter, a granddaughter, and a sibling. You took away so much unrealized potential, her potential to enrich other people's lives and to contribute to our society. You also traumatized the young men and women who mistakenly drove up your driveway that night. You will scar them, this will scar them and traumatize them for the rest of their lives. Any remorse you have isn't for the harm you've caused. The only regret you have is that you're finally facing the consequences for your actions. You murdered Kalen Gillis, you shot at a car full of people, and you didn't care what would happen, and you repeatedly lied about it. You deserve to spend the maximum time in prison allowable under our law. And I don't make this decision because it's easy. I make it because it's what's deserved. I make it because it's what's just. So as to the conviction of murder in the second degree, I sentence you to a term of 25 years to life in prison. For the conviction of reckless endangerment in the first degree, I'm following the law. I'm going to sentence you to a concurrent 2 1/3 to 7-year period of incarceration. As to tampering with physical evidence conviction, I can see why a court, might perhaps go along with concurrent because you received a 25-year to life sentence to begin with. But there was a delay. There was a lot of time you had between when the police showed up and you tampered with evidence. You had a lot of time to concoct lies. You had a lot of time to do things to the weapon, to tamper with it, basically, to try and destroy evidence. And because of that time that you had to think of those things and the conscious efforts that you made to tamper with that evidence, I think it is right that you receive a consecutive term of incarceration for that charge. So that's a 1 1/3 to 4 years of imprisonment. There is a matter of a $300 surcharge, $25 crime victim assistance fee, and a $50 DNA fee. Attorney Frost, is your client in a position to pay those funds now?
Not today, Your Honor.
Okay. And then we also have a couple pieces of paperwork that need to be gone over. One is a signature to authorize for DNA collection from your client, and the other is a notice of intent to appeal. We'll give those to you now for you to go over with your client.
I did first the notice, but here's the date.
Okay.
On count three, Judge, is that a consecutive or concurrent?
Consecutive.
It's consecutive to you.
We have a written form. We'll get to you. Yeah.
Judge, if I could, while we're waiting for the form, I would just please come by objection to consecutive seconds.
Noted. All right, and what's being prepared right now, Mr. Monahan, is a notice of intent to appeal. Just make sure to go over that with your attorney and make what selection that you think is appropriate. Anything else you need, Mary Kate? All set?
Hey, I'm just doing the commitment.
Okay. Oh, no, I just meant anything else you need us to cover. All right, and we received the notice of intent to appeal. Anything further from the people?
No, thank you.
Anything further from defense counsel?
Nothing wrong.
All right, sir, you're remanded to the custody of the Washington County Jail. Then you'll be transferred to the custody of the New York State Department of Corrections for service of your sentence. We're concluded.
Bye, Kevin. Coward!
Justice served. That concludes court.
Thank you.
Thank you.